Okay, so there's a small closing poll just to know anyone who would like to have a demo of Complinity compliance software for your organization may please register your interest so that my team can reach out to you offline after this webinar. The Complinity, as I said, is best suited for either MNC companies or listed companies or public sector undertakings or any company, be it manufacturing or services, which is more than 100 crore top line, because there we feel it's enough complexity for you to be, doing a compliance software. All right. So while people are filling up this closing poll, we will start with the Q&A. So Samir and Dr. Limaye, I'll do a rapid fire. I'll ask the questions. Anyone can pick up any question. I won't sort of a few questions which are low hanging fruits. Maybe I'll only quickly answer. But then, in the interest of time, we're already overshooting the time, and there are a lot of questions I see. So I'll be very, very quick and request you to be very brief and very quick as well. Okay, so Mayank says, what was Disha bill?
Related to hospital management, that's all. It
Okay.
didn't see a light of day.
Okay. So Siddharth says section 7(3) of the Act states that data principals should have the option to access the privacy consent in 22 local languages. So how will that?
So that I have prescribed that all scheduled languages it need to give notice. So company will keep a copy in all the languages, and if asked for, they can supply that particular copy. That's all.
If the data principles are primarily English, then we don't need 22 languages, right? Means the data principle has to be in that language also, no?
Yeah.
Understand. Rashmi says, do we need to take approval from the individuals for using their PAN card, Aadhaar card, passport when required for official purposes?
All personal identifiers, what Mr. Samir has already described.
Right. So all this is there. So that okay, this is done. Next is there any format for taking employee consent under the DPDP Act? Somnath asks.
It is the role of Complinity and lawyers like us to draft the same now.
Right. No format, but unless it is prescribed in the rules, or else professionals will have to sort of frame certain formats. When are the rules expected to be notified? It's anybody's guess, but yes, I think after the data protection board is sort of formed, we probably can expect. But I think in the next 3 to 6 months, we can see a lot of action, and especially in the next 1 year, a lot of action to sort of happen in the DPDP Act, right?
Yeah.
Divya Pahwa, so okay, I'm also Sumit Pahwa. Hi Divya. So I'll answer your question. Will this act cover on digital data or any non-digital form will also be covered? So I think section 3 has very clearly specified digital data is covered because the name of the law itself is Digital Personal Data Protection Act, DPDP. However, if a non-digital data is converted into digital, either through databases or PDFs or whatever, stored in a digital format, that will come under the coverage, right? Now, Mr. Parandhaman asks, please clarify right to privacy. What does this? Does it mean can I decline even if service provider needs my personal data, or right to consent? Does it mean I can provide the personal information, but I don't want my service provider to share or validate my personal information with government, etc.? Yes. Anyone would like to answer?
Yeah, so right to consent will be there. Again, it will come with some riders. If you provide consent to say 70%, 80% of that, then be offered to you. So companies will also change their strategies accordingly. Whatever is required to them, if that is provided in consent, company will provide 100% service. Or what happens with typical scenario? If you want to disable any feature of any app, they will say by disabling this feature, the app will not work to the extent of 100%. Then they discourage you. So same thing may happen. So consent, anyway, it will have to be what is required for that particular organization. So you have to be clever enough to accept that particular consent clause henceforth.
Regarding sharing with government, obviously nobody will share with government unless this is part of the regulatory. For example, if I need my Aadhaar to be confirmed, right Aadhaar number, so I have to go to the Aadhaar site and get an OTP and confirmation. So this question of sharing data with government will only happen if it is required, right? Unless it's an activity where there is malified intent, which we all understand, right?
Yeah, I'd like to add here that giving consent or not giving consent is entirely your prerogative as a data principal. Providing service or not providing service is the data fiduciary's prerogative as a data fiduciary, right? So if you do not give data, he may choose not to give you service. or give you partial service, and that's his right to give or not to give if you're not giving that data. However, if it is something that you really need the service, just like an Uber, for example, you cannot live without that service, and you do not want to give that data, and you have some valid logical reasons why not to give that data, and why should the fiduciary not ask for that data. There comes the role of Dr. Limaye and myself. You approach the professionals, then those things can be sort of challenged as a grievance to the DPO or in higher forums. Okay, how is the digital personal data different from personal data? I think personal data stored in a digital format is a digital personal data. No other sort of queries over there. Are the data captured by heat maps with as basic as the recognition of male, female, body shape, etc. is included?
It is biometric
Very,
data.
very much included.
Right. Mayank says, I run a pharmacy. In addition to my clinic, and the drug commissioner served me notice of not entering patient's address and patient's doctor's address in sales invoice. Did he serve the notice wrong? What can be my reply?
So yes, he is supposed to. I mean, there are prescription drugs which cannot be bought OTT over the counter. So yes, you need to have the address and the doctor's name there, which you need to again get a consent that you are buying these medicines. I need your prescription. Prescription should have your doctor's name, which it normally has. And yes, the drug controller has a right to ask you why the doctor's details are not mentioned in the bill. So that's very much within the legal framework.
Yeah, and I'd also like to highlight, I was reading a section in this act. I'm not able to I don't still remember the section numbers. But anyways, I was reading a section which says this act will act as a harmonious construction to other laws which are already there. So now in case of a pharmacy, the other pharmacy regulations will apply to you. In case of a banking and financial industry, the BFSI regulations, the RBI regulations will apply to you. Listed companies, heavy regulations will apply to you. So if as per suppose RBI regulations, certain KYC documents are mandatory, this DPDP Act is not coming in the way of those regulations. It will act harmoniously with them. If the sectoral regulation says you have to collect that data, so then the data fiduciary will collect that data. But as per this, they will sort of take consent, give notice, etc. So both the acts will sort of run simultaneously in collection of that data. So the sectoral regulators are not wrong in asking in case their sectoral regulations say so. Okay. Now, MJ says collection of information includes information shared through online mode or offline, submission of photocopy of PI documents. So we have covered that. I think offline, if it is converted to soft copies, it is covered. Otherwise, it is not covered. Can we store the company data also outside the country like financial data? Ratan Loda asks. While Samir said, yes, you may, I think I would sort of beg to disagree, and I'll say I have a different view. But still, I think clarity will emerge from the rules only.
DPP.
What exactly do they allow? What they do not allow? Is it a negative list or a positive list or a generic answer they give? I think better clarity will emerge from the rules only. Till now, it's anybody's guess what exactly will be allowed as a data localization or not. Okay. So are we saying physical is not covered? Yes, physical storage is not covered unless it is clarified in digital format. Okay. This question has been oft repeated, so I'm skipping the repeat questions. The physical versus digital. As per the recent amendments, Aman Agarwal asked, by MCA, we are not allowed to keep servers of our financial software outside India. So I think we have answered that question. Inside or outside India will be, again, if MCA, company law says the tally or financial softwares have to be kept in India. Now that section remains. Even if in DPDP Act, suppose they, as Samir said, they allow you to keep your servers abroad, say in US, even in DPDP Act, they allow you. But if MCA says your financial software has to be in India, then it has to be in India because this act is in addition to, not in subrogation to any other act. So
let me clarify that.
Yeah.
Nowhere it says that you cannot take the data and store it outside. It clearly says that primary copy of the data has to be always in India. It's the secondary copy we are talking about. The secondary is required because we have a concept of data disaster recovery, which means that the data is stored in data center, which is subject to, let's say, an earthquake or a flood or a power breakdown or something like that. So the DR copy can be kept anywhere in the world except negative list. Processing of data can happen anywhere provided you have taken the consent.
Right. No, very well. And also give you one practical example at Complinity. We are hosted on Amazon Web Servers, AWS. And earlier we were only on AWS Mumbai data centers. And as a DR measure, AWS opened a Hyderabad data center very recently, I think December 22. And we were one of the first organizations to have our DR site at AWS Hyderabad. So now we have BCP, DRP very well functioning with full data encryption, etc. Because we're also SOC 2 certified, ISO 27001 certified. And we feel it's not a compliance business, it's a data business that we are in. And data privacy, data protection has to be at the heart of everything that any company does anyways.
Let me tell you in one line, the DR activity normally is not location dependent. So your primary data, let's say AWS Mumbai, DR means they can actually keep your copy anywhere in the world and provide it to you at your ask. It's a live data image of the copy.
Right. Surely. Okay, Neeraj asks, how will the government regulated all those companies who are processing data outside? How will government regulate companies who are processing data outside? I think if the government comes to know something that is not allowed, you can receive show cause notices and stuff. How will personal data such as director email address that is present in the public domain be treated? So I think email address, mobile numbers are, as Samir also said, they are the most public numbers or public things. It remains to be seen if, despite those TRAI regulations, pesky calls and pesky messages have not stopped fully, right? So similar is the concept of email. If the spamming is not allowed and if somebody does it, if the grievances are sort of put, authorities answer, people can be booked. The law is, Stephen asked, the law is applicable for the data already collected. Do we need to take the consent? Yes, I think Dr. Limaye said, even for existing data prior to the commencement of the Act, there are very clear sections in the Act saying you still need to take consent for data collected prior to the Act. Right, Mr. Limaye? Dr. Limaye?
Yes.
Yeah. Buddhaditya, asked, will the DMAT ID shares held, etc. of investors and shareholders fall under the data protection? Yes, I think so. We have been talking about employee, customers, vendors. He's asking shareholders. Will that also be data? Yes, of course, it should be data, right? As long as it's an individual, it's a data.
It's a financial data, which is my personal data. It is covered.
Yeah, because the law says any individual data, any data pertaining to an individual is a personal data, and that is covered. Now that
financial transactions are clearly defined as personal data.
Right. Okay, Chetan says, what is the process of processing personal data further? For example, I've taken a passport of foreign national to apply digital signature and sent to another vendor. So again, the vendor is a data processor or a data fiduciary, depending on his role, and he needs to take care of the data security measures. What data is kept.
If he is not an Indian citizen, this law doesn't apply. If he's a European citizen, GDPR will apply. He says passport of a foreign.
If somebody is a European citizen, but he's taking a digital signature from India for some maybe MCA return. He may be a director in a company, something like that. So, in consent of the data principal, do we need to make the consent language a regional language? Yes, if your data principles are regional, you need to cover that in regional language also. Official email IDs will be covered as personal identifiable information. Just to recheck, Samir or Dr. Limaye, official email IDs, they'll also be PII?
Yes. Anything which is connected to me is PII.
Right. Okay. Somebody says, if such data is in public domain, is it okay to use or consent still required?
Who fetches the data? Consent is for the data fiduciary. If we are disclosing, that is, there is essential clause that if you voluntarily disclose any information about yourself, then that will be beyond purview of this particular consent. So here you have consented that particular public information to be used. So for those particular information, this is excluded. There is category of information, the information which is voluntarily disclosed by any data principal, that will not amount to this particular DPDP provision. So information voluntarily disclosed. Now you are sharing your visiting card. So you are disclosing voluntarily your information, e-card. So information voluntarily shared, that is out of the purview of this particular DPDP.
Right. But Dr. Limaye, it's a very thin area, I would say. If suppose on social media, there was an illustration also in the Act I was going through. if suppose somebody shares his or her mobile number and email ID on a Instagram or a Facebook or a LinkedIn post, and now if 100 other data fiduciaries who are scouting for a database, they crawl and they pick up that email ID, will that be means exempted because the person himself?
No, that is not exempted. See, please see, there is purpose when you are giving somebody a visiting card or you're sending a mail with your signature, with your visiting card address, everything. That's consent given to that person.
Right.
First of all, we should not share personal on Instagram or LinkedIn or anywhere. That's
Right.
point. All our websites have our official mail IDs and
Right.
sometimes numbers also. Government websites, you go to any RBI, SEBI, they need to
Display it.
list the mail IDs of their senior officers, including the office telephone number.
Right.
So that's already part of the public domain knowledge. Anybody can send a mail to the ex-official of any PSU because it's listed on the website.
Right.
Only reason is I can't start spamming them. I can't spam. If my mail ID is used for spam, for which I did not give a consent. So
Right.
like your misuse of the information is under covered. Not the right use is not covered.
Right. Okay, what is the provision for processing of hacked data, maybe even by legal agencies in any country? Samir, would you like to attempt? Sanjay is asking this.
So Sanjay, if you are an IT professional, hacked data is hacked data. It is illegal to use it.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.